Hi guys, welcome back to my channel Legal Awareness with Lady J. Today we are going to look at law enforcement agents and debt recovery in Nigeria. Do you know that it is actually illegal and unconstitutional to use law enforcement agency for debt recovery in Nigeria? Don't look back. Yes, it's you I'm talking to. Don't look back. It has become a norm to use law enforcement agents such as the police and the EFCC to recover debt. But is this right? Is it lawful? What does the law say about it? Let's look at what the law says. The law is that party cannot resort to the use of police or any law enforcement agency to pursue debt recovery claims. The primary duty of the police is, as provided for in section 4 of the Police Act, is the prevention of crime, investigation and detection of crime, and prosecution of offenders. So using the police to recover debt is seen as self-help under the law, and the law frowns at self-help. The police is not to it's not a debt recovery agency, and they are not to dabble into contractual disputes between parties arising purely from civil transactions. When a purely civil matter is reported to the police, such a person cannot go scot-free because he ought not have made the report in the first place. Such a report is said to be made mala fide, that is in bad faith, and such a person will also be equally liable for the action taken by the police, irrespective of whether he actively instigated them or not, since he ought not have made such a report in the first place in a purely civil matter. See the case of Madaki and another versus GT Bank and another. Therefore, the use of police to arrest, detain a person to compel him to pay debts, it's unconstitutional. The police officers are not empowered to recover debts for individuals or companies. In the case of Peter Nwaboshi versus the Federal Republic of Nigeria, the Supreme Court held that police is not a debt recovery agency, and therefore they cannot arrest you in connection with debt recovery. On the other hand too, it's not just the police, even the EFCC as well. The EFCC Act 2004 does not empower the commission, that is the Economic and Financial Crimes Commission, EFCC, to arrest and detain anyone or investigate cases of breach of contracts in business transactions. The commission only has the power to arrest, detain, or investigate financial crimes and not civil transactions. On few occasions, the Supreme Court had intervened on the unlawful use of the police, the EFCC, and other security agencies in the country to harass and intimidate individuals over debt collection. And the Supreme Court has also warned them to desist from such conduct. But due to corruption and overzealousness of some persons, such action has persisted. For instance, there was a ruling delivered by retired Justice C.D. Bagay in the case of EFCC versus Diamond Bank PLC, Petro Continental Nigeria Limited, and Dr. Peter Opara. The Supreme Court here in this case emphatically held that the EFCC is not a debt recovery agency and should refrain from being used as such. The Apex Court further held that the powers conferred on the EFCC to receive complaints, prevent or fight the Commission of Financial Crimes in Nigeria pursuant to Section 6 subsection B of the EFCC Act does not extend to the investigation or resolution of disputes arising from simple contracts or civil transactions. Police cannot be used to recover debt from you. The EFCC cannot be used. But however, let's take note that the police or the EFCC can only be involved where it will be lawful to involve them. It's where there are criminal activities in the monetary transactions, such as the issuance of dot check, fraudulent means of obtaining loan, etc. Here, agents like the police or the EFCC will be legally involved. So if the police and the EFCC cannot be used to recover debt, I know you want to ask, how can I recover my debt if somebody is owing me? There are stages to debt recovery in Nigeria. The first one is amicable settlements. Here, the debtor and the creditor, they attempt to resolve the issue directly to maintain the relationship. This can involve formal, maybe negotiation, discussion to agree on repayment terms. The second one is engagement of professionals. If the initial attempt failed, you can consult a lawyer, or there are debt collection agencies provided by the law you can provide necessary documentation to them, such as the invoices and agreement to support your claim. The next one is demand letter. You can send a formal letter through your lawyer. Your lawyer can send a formal demand letter, or you yourself, outlining the amount owed to you and payment expectations. This letter will serve as a legal notice and can prompt payment before further action is taken. Here, if the further action fails, what do you do? If there is a provision for mediation or arbitration clause in the agreement, before you file a lawsuit, you have to go for mediation and arbitration. This can often lead to quicker resolution of the matter. Fifth stage, or the fifth effective method of debt recovery, is legal action. So if you've done the first four stages and the debtor still remains indifferent, you can file an action in the appropriate court, such as the magistrate court, the state high court, or the federal high court, using the fast track procedures like the undefended list or summary judgment procedure. Then the sixth one is to enforce the judgment. Once a judgment is obtained, enforcement can be pursued through mechanisms such as the garnishee orders or writs of executions and the rest of them. So now, what do you do if the creditor uses police or any law enforcement agent to harass you? What will you do? What to do is to involve a legal practitioner who, depending on the circumstance, might bring action against your debtor for the enforcement of fundamental rights. Because using police to harass you, intimidate you, or threaten you, it's breach of your fundamental rights. So if such occurs, you can get your lawyer to file an action to enforce your fundamental rights.